Welcome everyone to our webinar on Boardroom 101, Director Responsibilities and Liabilities. My name is Rebecca Smith and my co-host here is Nina Vanderlaan. We are both lawyers in the corporate team here at LegalVision New Zealand. Before we begin, a couple of quick housekeeping items. So you will receive a copy of this recording and the slides in your email after the webinar. If you have any questions, we would love if you could submit them in the question and answers box as the webinar progresses, and we'll try to answer as many as we can at the end. We would also really appreciate if you could complete the feedback survey after the webinar. Just put onto our screen as a quick poll question we'd love to get your answers to. So the question is, what do you find most challenging about being a new company director? Understanding who qualifies as a company director, learning the key director responsibilities or duties, compliance with governance and law changes, understanding the consequences of non-compliance, or all of the above.
So by viewing this webinar, you're eligible to receive a complimentary consultation with LegalVision to discuss how we can help your business. So to claim, please leave your contact details in the survey that appears when the webinar ends, or you can contact us via our website.
Awesome. So today we will be discussing who are directors and the sources of their duties, what those key director duties are, some general defences, some other directors' duties that pop up, key governance matters, consequences for non-compliance, and if we have some time, some changes that are coming to companies law. I think we've got the answers to the survey now. Yeah, so the most popular answer was learning key director responsibilities or duties, which is great because that is probably the main focus of today. So we will get onto it. So I am first up with, sorry, my screen's just decided to do something weird, with directors' duties. So who are the directors? So the persons who are generally responsible for the management of the company. So the powers and decision-making power that they have will be governed by documents like the company's constitution, a shareholders agreement, and any duties at law. For limited liability companies in New Zealand, there has to be at least one director appointed. That director has to ordinarily reside in New Zealand, although this requirement can be satisfied by a director who resides in Australia and is already the director of an Australian company. Any person appointed as director must be at least 18 years of age, and they have to consent to act before they're appointed. The initial directors are the people nominated as directors at the time of the company incorporation, but after incorporation, new directors can be appointed either by the shareholders at a shareholders meeting, by other directors, or by a single shareholder. Ultimately, it depends on the terms of the company's constitution or the shareholders agreement. Now I'll hand over to Nina, who's going to start talking to us about some of the directors' duties.
Thank you, Bex. So as an overview of where directors' duties come from, there are three general sources of these. The first is the Companies Act, which was passed in 1993. This is the key piece of legislation that governs companies in New Zealand, and it explicitly sets out various duties that apply to directors. The second source is through common law, which is the law that's developed over time through court cases, and these duties are what's known as fiduciary duties. And then thirdly, there are some other pieces of legislation out there as well that also impose additional duties on directors. We don't have time to go into all of the directors' duties today, but the main ones that you need to be aware of are listed here on the right. These are the duty of care, duty to act in good faith and in the best interests of the company, the duty to disclose conflicts of interest, and the duty to prevent reckless trading. So let's go through some of these key duties. The duty of care is a director's duty that's owed under both the Companies Act and that directors are required, when you're exercising powers or performing duties in respect of the company, to exercise the care, skill, and diligence that a reasonable director would exercise in the same circumstances. That would take into account, but is not limited to, the nature of the company, the nature of the decision being considered, and the position of the relevant director and the nature of the responsibilities undertaken by that director. When a court is considering what a reasonable director would do, they undertake an objective assessment. but there is also some subjectivity applied because they must take into account the company's particular circumstances and the director's relevant office. So this means, for example, that executive directors, so your CEO, COO, CFO, general counsel, these people will have higher duty standards applied to them as compared to non-executive directors by virtue of their position and expertise that they bring to that role. So that means that where a director is appointed to a specific task, they may be liable for breach of this duty where they do not bring the required skills to that task. So by way of example, somebody in the role of CFO would have greater responsibility in respect of financial reports of the company than the other directors would. As a note to that point, the differing levels of skill and care expected from directors in respect of decisions, it only applies to this duty. The other ones are objective. So, what does this mean practically? Directors are required to take reasonable steps to place themselves in a position to guide and monitor the management of the company. This includes making sure you're familiar with the business and how it is run, ensuring there's adequate oversight and auditing of management functions, reviewing financial reports of the company, and attending and being engaged at all board meetings, unless, of course, exceptional circumstances exist. All directors are required to be able to read, understand, and focus on the content of reports that are presented to them. Directors must be able to consider whether financial statements are consistent with their knowledge of the company's profits and financial position. Directors must make any inquiries as necessary to ensure they can make informed decisions. And directors must have sufficient skills to perform their tasks. If you don't know how to perform a particular function, you're required to ask or seek appropriate external guidance. This slide shows some common law examples where courts have found directors to have breached the duty of care. So where a director acted before becoming fully acquainted with the company's affairs, where loans were made to a company connected to a director with no possible benefit to the company, only benefit to the director, where checks were signed in blank and the conduct of the business was left entirely to another director, where a director unquestionably trusted employees with the management of the company when those employees were subsequently found to have acted dishonestly. Overall, as a director, you should make sure you understand the business of the company and always exercise informed independent judgment. Don't rely on other directors to inform you. I'll now hand over to Rebecca to discuss the next key duty.
Thanks, Nina. So the next one we're discussing is the duty to act in good faith and in the best interest of the company. This is another duty that's owed under both the Companies Act and common law. Excuse me. A director must act in good faith and in what the director believes to be the best interest of the company. While unrelated, it's also good to discuss here the duty together with the duty to exercise a power for a proper purpose. So good faith is subjective, and that a director must genuinely believe that he or she is acting in the company's best interest. Generally speaking, the company means the shareholders as a whole, not an individual shareholder. And also if a company approaches insolvency, this would also include taking into account the company's creditors. Where there is a corporate group, so like a holding company and its subsidiaries, a director of a wholly owned subsidiary will be taken to have acted in the good faith and in the interest of the subsidiary if the Constitution expressly allows directors to act in the best interest of the holding company. And the director acts in good faith in the interest of the holding company, and at the time, the subsidiary isn't insolvent. So as I said, tying in with this is proper purpose. It is not sufficient that a director honestly believes their actions are in the best interest of the company if they exercise a power for an improper purpose. In determining what is a proper purpose, the purpose motivating the exercise of power must align with the objective purpose for which the power was granted. Some examples of this are the directors may have the power to issue shares. However, the directors issuing shares substantially for the purpose of diluting one or more shareholders would be seen as an improper purpose. Another example we've seen under case law here, a board believed the takeover bid for a company was not in the best interest of the company, so allotted weighted preference shares to a trust that was sympathetic to the board's view in order to stop the bid. Again, it's an improper use of power to allot those shares. Now I'll pass back to Nina to discuss the next duty.
Thanks, Bex. So under the Companies Act, directors are required to disclose to the company when they have a conflict of interest in respect of a proposed transaction to which the company is a party. And this disclosure must happen as soon as the director becomes aware of the fact that a conflict might exist. A conflict of interest occurs when a director's interest and the interests of the company overlap. In those circumstances, a director may be interested in the proposed transactional deal such that the interest must be disclosed. As a director, you'll be interested in a relevant transaction in the following circumstances: where you're a party to the transaction, so for example, where the company is issuing new shares to you as a shareholder, where you derive some material financial benefit from the transaction. So for example, if you're an executive director and you're entitled to a bonus in respect of certain business transactions being achieved, like selling a division of the business, where you have a material financial interest in another party to the transaction. So a classic example there is where the company might be engaging services from another company and you own that company or you're a shareholder of that company. Where you are a family member of another party to the transaction. So that same example I just gave, but where, say, your partner owns that company. And where you are otherwise directly or indirectly materially interested in the transaction. This last is a bit of a catch-all, so ultimately, if you have any doubt about whether a conflict exists, just disclose it. Disclosing offers you the best protection against potential liability down the track, and of course, we always recommend have a chat to a lawyer if you're not sure. When you make your disclosure, it should include the nature of the potential conflict that exists, including, where possible, the monetary value of that interest, if it can be quantified or represented as a monetary value. Or if not, then the extent of that interest. At a minimum, legally, your disclosure must be made to the board of directors and entered into the company's interest register. This is required even if you are the only director of the company. If you fail to disclose a conflict of interest that exists, then this is an offence under the Companies Act and you may be liable to pay a fine of up to $10,000. So again, if you're not sure, always default to disclosing. Just a few extra points around this requirement here. So just because an interest is disclosed and or approved, it doesn't mean that a director is completely off the hook. You must still continue to satisfy all of your duties that apply, including those overarching duties to act in the company's best interests and with that care, skill, and diligence. Also, if the company has a constitution or a shareholders agreement in place, then these may impose additional restrictions regarding directors' interests, requirements regarding disclosure of interests, or other procedures to be complied with by interested directors. So, as always, it's important to make sure you're familiar with any requirements that are included in your company's governing documents. Where a director has disclosed a conflict of interest, there's an opportunity for the company to avoid the transaction at issue. This can only be done within 3 months following the transaction's disclosure to the shareholders, which may be at the time of the transaction or after the fact. However, this cannot be utilised where all the shareholders of the company have already consented to the transaction with full knowledge of the director's conflict of interest. To give certainty to the company that a transaction is not going to be voided later, it's usually standard practice to get the shareholders' approval at the time that the transaction is being proposed. Equally, the transaction cannot be voided if the company receives fair value under it. This means that if the transaction's been entered into in the ordinary course of the company's business and on the company's usual terms and conditions, then fair value would be assumed. So the key takeaway of this duty is that, especially in a small country like New Zealand, it's not uncommon for conflicts of interest to arise in the performance of your duties as a company director. However, it's vital that you disclose these matters as soon as you become aware of them and in the appropriate manner to your company and your fellow directors, if you have any. Disclosure ensures that you comply with your obligations and you can continue to act in the company's best interests, while failure to do so can result in a hefty fine. Finally, we suggest that you remember that managing conflicts is about more than just complying with your statutory requirements. If the associated risks and implications are not managed, they could lead to significant consequences, including reputational damage and loss of shareholder and stakeholder value. I'll now pass back over to Rebecca to talk about the next duty.
Thanks, Nina. So duty to prevent reckless trading is another duty that's owed under the Companies Act. A director will be in breach of this duty if either They agree the business being carried on in a way that is likely to create substantial risk of serious loss to the company's creditors, or they cause or allow the business to be carried on in that way. So in short, a director can't agree to the business of the company being carried on in this way or cause or allow it. The inclusion of allow suggests that a director may be held liable in circumstances where, with no actual knowledge of the business of the company, has been happy to leave their responsibilities to a more active member of the board. This duty will apply even when a company is not in liquidation. So how is this applied? This is a test that is subjective. So that would mean, how would an ordinary, prudent director be expected to act in those circumstances? The key here is a focus on the concept of recklessness. So typically, you need to ask whether there is something in the financial position of the company that would have drawn the attention of an ordinary, prudent director to the real possibility that continuing to carry on business would cause serious loss to the creditors. It doesn't matter if the potential risk of loss to creditors is being undertaken because it is counterbalanced by a greater reward if the business succeeds. So in short, the expectation here is for directors to follow orthodox commercial practice and not undertake illegitimate business risks that the creditors of the business would not reasonably anticipate the business would take. So in practice, before undertaking a transaction, directors should be satisfied that the company will pass the solvency test. This test requires directors to be sure that after completing the transaction, the company can still pay back creditors in the ordinary course and assets will exceed the value of liabilities. If it is not satisfied, then the company could be deemed to be engaging in reckless trading, which directors would be held personally liable for. There is some distinction of illegitimate versus legitimate business risks being taken. Recent cases have confirmed that reckless trading will only be found if illegitimate risks are undertaken. So what does this mean? In the example of an insolvent company, even if it's just insolvent on the balance sheet, this does not mean that the company is required to immediately stop trading. Instead, there will be some scope for directors to continue to allow the company to trade in a way that ensures the situation will improve. So for example, consider and address the reasons the company is insolvent and put strategies in place to lift the company out of the situation if they decide to continue trading. Typically, this should only be for a short period. Directors who allow an insolvent company to trade for extended periods of time are increasing that risk of being held liable for reckless trading. So there was a recent case law example of this where it was found a director conduct was not to be reckless, where the directors acted with the full support of the creditors and the creditors were fully aware of the risks which were substantial. There was a common strategy here between the directors and creditors. So here, the court recognised that all business is inherently risky, but again, the test is whether the risks taken are legitimate business risks. And now I'm going to pass back to Nina for some general defences.
Thanks, Bex. So there are some very limited defences to the main director's duties that are available to directors, but please note that none of these are guaranteed. The first possible defence is that you, as a director, relied on information or advice from other persons when you were discharging your duty. In certain circumstances, a director can rely on information or professional expert advice that's given or prepared by others. So, for example, if an employee of the company, or you rely on advice from an employee of the company that you reasonably believe to be reliable and competent in relation to the relevant matter, or you might have received advice from a professional advisor or expert if the director reasonably believes that the relevant matters are within that person's professional or expert competence. So that includes lawyers, accountants, auditors, etc. A director's reliance on such information or advice is presumed to be reasonable if the reliance was made in good faith and after the director made an independent assessment of the information or advice, having regard to the director's knowledge of the company and the complexity of the structure and operations of the company. That means directors must still bring an independent mind when considering professional or expert advice and must not simply accept the views of others. The other possible defence is what's known as ratification. This involves the shareholders of the company retrospectively approving the conduct of a director. How ratification occurs may be set out in the company's governing documents, but it's typically done by way of a shareholder resolution approving the relevant conduct or action. However, there are several limitations to this. Directors' duties under any legislation cannot be ratified. Ratification requires full knowledge of any breach and the effect of that ratification. Shareholders must not have the same improper purpose as the directors at issue. The ratification must not amount to fraud, cannot cover misappropriation of resources, cannot jeopardize the rights of creditors, cannot defeat a shareholder's personal right, and directors cannot use their own power as shareholders to approve ratification. So that's in the situation where a director is also a shareholder of a company. I'll now pass back over to Rebecca to touch on some other directors' duties.
Thanks, Nina. So over the last couple of decades, various legislation has been introduced which does impose specific obligations for directors and or personal liability. The first one is workplace health and safety. So generally, the rule is that each director must take reasonable and practical steps to ensure the health and safety of workers whose performance of work activities is influenced or directed by the company. Directors are also expected to undertake due diligence regarding workplace health and safety matters. So this includes being familiar with workplace health and safety matters, understanding the operations carried out by the worker, monitoring incidents, hazards and risks, ensuring workers have appropriate processes and resources for eliminating or minimizing those risks, and facilitate consultation on workplace health and safety issues. Another duty or, I guess, obligation we're seeing is around environmental regulations. So recent litigation, both in New Zealand and globally, has highlighted the increasing need for directors to consider the impacts of climate change when exercising director duties and making decisions for their companies. The Court of Appeal has recently rejected the notion of a general duty of care regarding climate change, finding that there are strong policy reasons against this. However, regardless of where this case ends up landing, the door will stay open for shareholder claims against directors in the climate context based on breaches of their statutory duties. Directors should be considering the realities of climate change and the impact of their actions when making company decisions. So in other words, suppose directors take a course of action they believe to be in the best interest of their company. However, the realities of climate change impacts can be shown to negate any of the perceived benefits for the company. In that scenario, the directors may be at risk of being in breach of their duties for not having appropriately considered and mitigated those impacts. Even beyond the potential litigation risk is the associated reputational risk. Climate change is becoming an increasingly prominent issue in the public consciousness, with the public and investors alike putting more pressure on companies to be taking affirmative action with respect to the environment. Another area we're seeing come up is New Zealand consumer law obligations. So directors can be personally liable for being directly involved in or abetting in the company's breaches of New Zealand consumer law. So this might include unconscionable conduct, misleading or deceptive conduct, unsolicited agreements, and breaching consumer safety provisions. And then a nice catch-all, which I'm not going to go into in detail because we'd be here all day, is crimes such as money laundering, bribery, corruption, terrorism, and fraud. So again, they're not directors' duties per se, but they are important things to take note of and be aware of in a business. And now I'm going to pass it back to Nina.
Thanks, Bex. So on this slide here, we have a list of key matters that directors are expected to stay on top of. All of these will help assist you to remain in compliance with your director's duties. So let's go through them. It's important that you ensure that records are kept of meeting minutes, resolutions, books, accounts, etc. of the company. Maintain the company's registers, so that's your share and your options registers, documenting the details of those holdings as required by law. Maintain the company's office register, so for example, updating those records when there are changes to the company's address, shareholders, directors, etc. Often there are statutory timeframes that apply to making these sort of updates, so it's always important to check what these are to ensure you remain compliant. Make sure you're familiar with the company's state of affairs, so for example, financial reporting and auditing. Depending on the size of your company, there might also be additional reporting obligations that apply. As noted previously, make sure you're making full and frank disclosures of any conflicts or potential conflicts as they arise. Try to ensure that you're being fairly and responsibly remunerated. Stay on top of risk recognition and management. Regularly hold board meetings as needed to ensure the good governance of the company. So usually we would expect this to be at least quarterly. Ensure the company is holding an annual general meeting of shareholders, which is required by law. ensure that any meeting is being called and held in accordance with the terms of the company's constitution or shareholders agreement, and then ensure that any voting that takes place at those meetings is also being done in accordance with the provisions of those documents or the Companies Act if those documents aren't in place. So as you can see, these responsibilities are wide-ranging, but they capture some of the steps directors can be taking to ensure they remain in compliance with their duties. On this next slide, we have some protections directors or the company can consider putting in place. So the first is a deed of indemnity, insurance, and access. This is a promise from the company to the director saying the director will be indemnified, insured, and given access to company documents insofar as required to perform their function as director. It's not possible to be indemnified or insured for willful breach of duties, and some duties can't be covered at all. So there are limitations to this, but it can still be worth doing and give directors a bit of peace of mind, particularly where the company operates in a high-risk environment. The other option, which is usually given alongside the deed, is putting in place director and officer insurance, which is known as D&O insurance. And this is, as it sounds, insurance where the company pays a premium and the insurer covers the director for any penalties the director might face. Again, this is limited in similar ways to the above. I'll now pass back over to Bex to cover off our final points.
Thanks, Nina. So this one's going to be about consequences for non-compliance. So government bodies, most notably here for companies is the Companies Office, may seek declaration, impose penalties, which may be criminal or civil, depending on the offence, get compensation for the company, or disqualify a director from being a director for a period of time. The company itself, including shareholders, through derivative action, the board or liquidators may get compensation or get an account of profits. The penalties for breaching the Companies Act can be severe. So a director or an officer who fails to perform his or her duties, in addition to having to pay a penalty, could be convicted of a criminal offence, incurring a fine up to $200,000 or imprisonment for up to 5 years. So it's really important to be careful that you are on the right side of the Companies Act, and if you have any questions, to get some advice on that. The next is a bit more exciting. So there is some change coming, and there's been a lot of talk in the company law space, and the government is currently in the process of modernising the Companies Act, which has been in place since 1993, and then any other related legislation that kind of crosses over with that act. So the intention of the reform is to help make sure the rules governing companies are clear, workable, and fit for purpose. They are looking to do this in 2 phases. So phase 1 of the reforms will focus on changes to the Companies Act to better reflect the modern business environment, while phase 2 will include a review by the Law Commission of Directors' Duties and related issues of director liability, particularly in light of and looking at that Mainzeal case and its impact on these. The Commission is expected to get underway this year with a bill to Parliament in the second half of 2025. So none of this is concrete yet, but it's obviously part of the conversation. So in the Mainzeal case, the Supreme Court issued the final say in 2023, and this was significant because it fundamentally reshaped director liability in New Zealand, establishing that directors can face personal liability for company debts where they breach their duty to prevent insolvent trading. The threshold for establishing breach is relatively low, focusing on what directors knew or ought to have known, and personal guarantees and defences available to directors may be more limited than previously understood. So I think it's going to be really interesting to see the changes that come out of that. On this basis, the Law Commission's review is expected to examine the clarification of those duties, so providing clearer guidance on the practical application of existing duties, particularly around financial oversight, excuse me, and insolvent trading. The liability framework, so reviewing whether the current balance between accountability and commercial risk taking is appropriate. Safe harbours and defences, so considering enhanced protections for directors who take appropriate professional advice or follow proper processes. And then some considerations for smaller companies, so examining whether the different standards should apply to a smaller company versus the larger corporations or enterprises. I think some more guidance on these issues is going to be really welcomed by the business community and also those of us working in the corporate legal space. It's exciting changes. Another important change that's popping out of these conversations, which we have found ourselves discussing with clients on a semi-regular basis, is that the potential ability for directors and shareholders to replace their residential addresses on the Companies Office, which is a public forum, with an address for service. which should address some concerns that some directors or shareholders are having around privacy and safety of having their personal residential addresses up on the web. So as I noted, these are all up in the air as to what the actual changes will look like, but it is promising to see the government taking these steps to modernise legislation and keeping up with how business is done in 2025, along with providing some important guidance on the director liability framework. Until then, though, we recommend directors to keep their duties and obligations front of mind, particularly around, as Nina mentioned, financial monitoring and getting early intervention when companies face difficulties.
Wonderful. Thank you very much, Rebecca. That concludes the main part of our webinar. We hope you found it valuable. You might also find our New Zealand Directors' Duties Guide useful, which you can locate in the Resources tab or by scanning the QR code on the slide. You might also be interested in our upcoming event on structuring your business for success, which is being held at midday on Tuesday, the 5th of August. If you are interested, you can register at the link on the slide there. So we're going to go to Q&A shortly, but before we do that, and while you submit any final questions, we'll take a minute to tell you about LegalVision's membership. So by becoming a LegalVision member, your business will get unlimited access to our full team of over 100 specialist lawyers for all of your business as usual legal needs. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, including, of course, advice around governance and complying with your director's duties, as well as unlimited domestic trademark registrations and much more. As a LegalVision member, you won't have to worry about the cost of lawyers ever again. You can think of it as having your own in-house counsel for a fraction of the cost. We'll take care of all the business as usual legal work so you can focus on running your business. And if you are an in-house counsel, we also offer a dedicated service to manage your high-volume business as usual legal tasks. If you'd like to learn more about how membership or desk extension can help you, please request your free consultation when the survey appears at the end of this webinar. So we will now turn to Q&A. I'll go first. One of the questions we've received is, should a board always seek external expertise and advice on cybersecurity? Which is a great question. And I think the answer is it depends. So if there's a director who's on the board of the company or a dedicated employee of the company that has the relevant expertise, then potentially that person can provide this advice to the board. Bearing in mind, of course, what we were talking about in the main part of the webinar about the fact that even when you are receiving expert advice, that you still always, as a director, need to apply your own independent thought to it. You can't just rely on that as, given. And so then on the flip side of that, where the expertise isn't already present in the company or at the board level, yes, we would suggest that boards strongly consider seeking external expertise and advice. And that's particularly given, the increasing frequency and sophistication of cyber threats that are happening these days, ensuring, in order to make sure that you're complying with your duty of care and requirement to act in good faith and in the company's best interests. There's definitely an argument there that if you aren't turning your mind to this, and I was going to say, particularly if you're an online company, but pretty much all businesses have got an online component now, and most companies do collect some degree of personal information from customers and or suppliers, etc. So there's always an element of that threat present. And so it is important that you turn your mind to that. And also sort of thinking about, the risk that you can face as a director of potential personal liability if a cyber breach does occur, and that's due to inadequate oversight from the board. I think generally we would expect most boards to lack the relevant sort of technical expertise to properly assess those risks. And so where that situation applies, do recommend that you engage external experts, and they can help you with things like initial risk assessments, development of internal policy relating to cybersecurity, and also then periodic reviews to make sure you're on top of things and minimizing that risk as much as possible. I think it's worth saying, and this applies to so many sort of legal considerations, that even though there is a cost involved with doing, getting that external advice, almost always that's money well spent, and in the scheme of things is minimal as compared to the consequences of any potential breach that might occur. Just having a look at the question, somebody else actually asked what the biggest risk is that's facing boards across New Zealand, and this is actually probably one of the biggest ones, because it really represents sort of the convergence of several risk factors that exist. And so, there's increasing regulatory requirements happening, including under the Privacy Act. There's growing sophistication of attacks, huge potential for financial and reputational damage, and then, of course, the potential exposure to directors. So for all these reasons, the long and short of it is, yes, we would absolutely recommend that you get that external advice, unless, of course, as mentioned at the beginning, somebody within the company already has that. Cool. I'll pass over to you, Bex, if you want to pick one up.
Yeah, thanks, Nina. So we had a question that says, can you comment on the director liability/risk in the context of health and safety? So it is a good question, and I've mentioned it previously, directors can face significant exposure under the Health and Safety at Work Act. Of course, the risk and the extent of that risk here would depend on the industry the business operates in, with some industries, I guess, being more inherently dangerous or riskier than others. That being said, and as I said earlier, all directors need to be considering the health and safety obligations in the workplace and ensuring they comply with those obligations. And when they fail to do so, the fines and the liability under the Health and Safety at Work Act is a lot higher than the Companies Act. So some of those fines are looking at up to $600,000, along with other potential civil liability claims. So it's important, to really keep on top of those obligations, not to mention reputational damage and risk or disqualification from director eligibility. Because the risks, I guess, vary so much between industries and types of work, it's probably best here that we would recommend to engage with a health and safety advisor for your business to ensure that you're complying with the requirements and that your policies are all in place to ensure compliance. So we'd recommend things like, as I said, establishing robust health and safety systems, ensuring the board is receiving regular reporting on your company health and safety matters, including staying informed of any workplace risks, and ensuring adequate resources are made available for health and safety compliance. So it's probably one of those areas, and I mean, our employment team can speak to this to more depth than the corporate team, but it is an area we're seeing more and more requirement for compliance. So it's really important to keep on top of that one. It's a good question.
Thanks, Bex. I see a question here about sort of top 3 risks and issues that new directors need to know generally, given that in New Zealand we do not have a mandatory training before a person can be a director. So I think probably sort of the top risks and issues would be, firstly, like a subpar understanding of the legal duties that apply. I think it's quite common that many new directors will underestimate the legal obligations that apply to them. They don't appreciate how quickly personal liability can arise, particularly in a tax context, and in health and safety as well. Coming to a webinar like this is a great starting point in terms of trying to familiarize yourself with what those duties are. There's lots of resources that are available out there. There's a body called the Institute of Directors. They do offer, even though it's not mandatory, they have lots of online courses that are available, which are great to check out and great to do if you want to upskill in your obligations there. The company's office has lots of good free resources, and lots of law firms, including ours, of course, offer resources as well. And then, of course, like consulting with a lawyer is always a great idea. One of the other kind of key issues is poor information and reporting systems. So basically, you can't be discharging your duties appropriately unless you have the proper information at hand to inform your decision making. So it's really key that companies have got like robust management reporting in place, and sort of staying on top of compliance and making sure things are as they should be. And then I think probably another thing to flag is just the insurance and indemnity point that we kind of talked about at the end there. Just making sure that you're staying on top of those, identifying any gaps, and just making sure that directors are protected as much as possible, reviewing those policies regularly and ensuring you've got adequate sort of coverage limits on those. I don't think I'm just sorry, looking at the questions, I'm not sure we have time to dive into any of the other ones today, but looking sort of at the flavour of the questions we have, some of them are quite specific and probably too specific for us to really answer in this forum. So we would really encourage you to make the most of the free consultation that you can get from our webinar. And we can always, have a chat about your specific requirements. There is one question here about the case reference for the Mainzeal case that we spoke about. I'm sorry, I don't know it off the top of my head. I don't have the ability to look it up right now. But either again, if you send that question through after the webinar, we can share it with you. Or if you do a Google search for Mainzeal case director duties, you should be able to find it quite easily.
I imagine there's a lot of commentary out there on the Mainzeal case that should guide you on that one.
Absolutely, absolutely. So sorry if we weren't able to get to your specific question today, but thank you again for attending. Once again, if you could please submit your details in the survey at the end for assistance with any of those questions we didn't get to, or if you'd like to learn about how our membership can help you, please do that. Also, while of course this is a free webinar, we really value feedback about how we can make these better in the future. So if you could also take the time to complete the 30-second survey at the end, we would really appreciate that. Thank you again for joining us, and we hope you have a wonderful day.